Good morning to one and all. I personally thank Mr. Senior B. Mohan sir for introducing me to this forum. And in fact, incidentally, I want to place a mention here that constitutional law is a forgotten field before the trial courts. But in my 25 years of experience, I have seen the only advocate from the trial court who used to refer the constitutional provisions very often is Mr. B. Mohan, Senior Advocate, because he is not only a lawyer by profession, and he is a social activist, and he rises to the occasion wherever injustice is happened inside the court or outside the court. So incidentally, he used to refer the constitutional provisions. Therefore, we can't, as Mr. Mohan sir said, we can't ignore the constitution as if it is confined only to the high courts or Supreme Court. It is not so. In fact, you take any law of the land which is in force as on today, all the laws in India should be in consonance with the constitutional provisions. If any law which is in derogatory to the constitution will be declared as ultra vires. Therefore, all the laws should meet the constitutional mandate. Now, this is an important topic in the constitution. As Sir said, the Article 32 and Article 226 is very, very important provision in our day-to-day practice. First of all, I am not a constitutional expert to go into the intricacies of constitutional provisions. In my day-to-day practice, I have learned a little about this writ jurisdiction, which I am going to share it before you for easy understanding. In fact, you know well, constitution is growing. It is a living organism. It is not a static one. Every day law is developing. If you take the judgment of A.K. Gopalan in AR 1950, till the recent pronouncement of the judgment in Justice K.S. Puttaswamy case, right to privacy, you can see lot of developments and march of law in the constitution. There are a number of judgments have come by interpreting the constitutional law. In fact, this constitution came into force on the day of on the Republic Day on 26 January 1950, and writ jurisdiction of the High Court under 226, writ jurisdiction of the Supreme Court under 32 are very, very important provision. Writ means nothing but an order in writing. An order in writing. There are many kinds of 5 kinds of writs as on today. Normally, as Mr. B. Mohan sir said, when you have an alternative remedy before, common law remedy before civil court or criminal court, writ will not be entertained. But writ will be entertained wherever your right has been infringed by the authorities or anyone who is having control over it. So normally writ will lie mainly on 3 reasons. Firstly, in violation of fundamental rights. Wherever violation of or infringement of fundamental right has come, then you can invoke the writ jurisdiction. Secondly, any order or any decision has been taken in violation of the principles of natural justice. Thirdly, an order passed by authority which is without jurisdiction. So these are all the very basic aspects for invoking the writ petition. There are other aspects which we are going to deal with it later. But mainly on these reasons: 1, violation of principles of natural justice; violation of fundamental right; 3rd, without jurisdiction. Only on these grounds, writ petition is maintainable. But writ petition is not an appellate authority. You can't make use of the writ jurisdiction as an appellate authority. When you have an alternative remedy available in any other law, you have to go before. But it is not an absolute rule. In extraordinary cases, the High Court is entertaining the writ petition despite the alternative remedy in order to set right the apparent wrong committed. And but invoking writ, one should have a legal right. Without a legal right, you cannot invoke. Similarly, that legal right should have existed already. You cannot make use of the writ jurisdiction for the purpose of creating a legal right. That is not permissible in law. And writ jurisdiction is concerned, there are two kinds. One Article 32, another Article 226. I am not much conversant about Article 32 of the Constitution, but however, I have limited knowledge about Article 32. A literal reading of Article 32, you can find that it is confined only to the violation of fundamental rights. Suppose if anyone wants to approach the Honorable Supreme Court by way of writ, he should make out a case that there exists a violation of fundamental rights. Only when there is a violation of fundamental right, then you can invoke the writ jurisdiction of the High Court. You can challenge any enactment, you can challenge any order, but you should show that the subject matter of challenge in that writ petition is violative of the fundamental rights under Part 3 of the Constitution. Part 3 of the Constitution is exclusively meant for fundamental right. An interesting note is that if you take Part 3 of the Constitution, which deals with fundamental rights, Article 12 to 35, Article 12 to 35 comes under the Part 3 of the Constitution. Incidentally, Article 32 also comes within the Part 3. So the jurisdiction of Supreme Court under Article 32 is also a part of fundamental right under Part 3. Therefore, the scope of the Supreme Court under Article 32 is only in case of violation of fundamental rights. We cannot invoke for other purposes. Whereas the power of the High Court under 226 is concerned, if you read 226 subclause 1, it is not only in respect of violation of fundamental rights and also for other purposes. The word other purposes have been defined in very many cases. So you need not confine yourself to approach the High Court only when there is a violation of fundamental rights. You can approach the High Court for any violation of your legal right. So the scope of, in fact, there are a number of judgments of Supreme Court which says that the scope of Article 226 is wider than the scope of Article 32 of the Constitution. In fact, this scope of 32 of the Supreme Court has been elaborately discussed by the Honorable Supreme Court in 1987, 1 SCC 395. 1987, 1 SCC 395 Constitution Bench. The second judgment is a celebrated judgment in the Indian judicial history. That is Kesavananda Bharati case. Kesavananda Bharati case, 1973, 4 SCC. 1973, 4 SCC 225. This judgment has not been overruled, even though an attempt was made earlier. But this judgment specifically deals that the basic structure of the Constitution cannot be altered. And it is a classic case, and it is a very lengthy judgment. And you can find each and every aspect of the Constitution in this judgment. Only in this case, the Supreme Court has held that the power of judicial review over legislative action vested under Articles 32 and 226 is an integral and essential feature of the Constitution, constituting part of its basic structure to test the constitutional validity of legislation can never be boosted or excluded. So the power of the Article 32 and 226 is a sacrosanct, is the view taken by the Honorable Constitution Bench in Kesavananda Bharati case. And normally, you can find a very good judgment of the Honorable Supreme Court authored by Honorable Justice Iqbal J in 2016 to SCC 315. 2016 to SCC 315 equivalent to AR 2015 Supreme Court, AR 2015 Supreme Court 2940. In this case, the Honorable Supreme Court has nicely distinguished the difference between Article 32 and Article 226 of the Constitution. Now, let us go into the kinds of writs. There are 5 kinds of writ petitions. First writ petition is writ of mandamus. Mandamus means a command to do something, or a command to forbear the authorities from doing something. So, simple act of command is the scope of the writ petition. But to invoke the writ of mandamus, it is quite often, very often, writ of mandamus alone is being filed all over the country. if you take the statistics, then you can easily find that only writ of mandamus are occupying the writ courts to considerable extent. To invoke the writ petition, writ of mandamus, you must establish that there is a legal right in your favor, and there must be a corresponding obligation on the part of the authorities to perform. So you cannot just like that file a writ petition unmindful of the subject matter in issue. You must have some legal right. That legal right has not been respected or not implemented. Then correspondingly, that authority against whom the petition has been filed must have an obligation to reciprocate your legal right. Only then you can maintain the writ petition. There are empty number of judgments from 1954 onwards, but I would only quote two recent decisions of the Honorable Supreme Court, which includes all the previous decisions. Firstly, 2020 9 SEC 356. 2020 9 SEC 356. Next one 2008 2 SEC 280. 2008 2 SEC 280. So, to issue a writ of mandamus, there must be a legal right with the party asking for the writ to compel the performance of some statutory duty upon the authorities. So, this is a basic thing. Nowadays, the number of writ petitions are being filed, and it is being disposed of to direct the authorities to consider, which would indicate that the grievance of the parties are not met by the authorities. In fact, there is a similar corresponding provision is there under section 80 CPC. You know well that before instituting a suit against the government official, you must give a notice to the authorities. Namely, there must be a request, and the rejection of request will create a cause of action. And the constitutional validity of the CPC amendment was tested before the Supreme Court in Salem Bar Association case 2005 6 SEC 344. Honorable Supreme Court has made it very clear that in every district, the concerned state government should nominate an officer for the purpose of alleviating the grievance of the petitioners, namely the persons who are giving the petitions or complaints during to ventilating their grievance. So there must be an officer appointed in each and every district. Even though judgment was delivered in 2005, now after 15 years, no such officer has been appointed. So the giving of such a prior notice before filing of the suit is of no use as on today. Similarly, for it to the people are approaching the High Court, complaining inaction on the part of the authorities. So there must be a mechanism available for the purpose of to meeting the grievance of the people, so that this process can be curtailed. Secondly, writ of certiorari. This is another important provision in Article 226 or Article 32, which says that whenever a body of persons having authority to determine a question affecting rights of the people have acted excess of authority. Suppose an order has been passed without hearing the persons affected, an order has been passed infringing the fundamental right of the person concerned, or an order has been passed without jurisdiction, definitely those orders can be challenged before the court of law by of filing writ petition under Article 226. So, certiorari means that if an order has been passed wrongly or violation of principle of natural justice or against the fundamental right, that order can be straight away questioned by way of writ petition under Article 226. There are a number of judgments of the Honorable Supreme Court right from AR 1947 Privy Council 90. There are a number of judgments. After Constitution, AR 1952 SC 192. There is a first judgment. AR 1952 SC 192. The Honorable Supreme Court has laid down a clear guideline for invoking. If you take any decision on the certiorari is concerned, you can find place the judgment. Then the 5 judgments of the Honorable Supreme Court in AR 1955 Supreme Court 233. AR 1955 Supreme Court 233. Then AR 1954 Supreme Court 440. AR 1954 Supreme Court 440. Then 2002 4 SEC 388. 2002 4 SEC 388. So then the latest one, 2019 10 SEC 695, 2019 10 SEC 695. Very recently, the division bench of the Madras High Court in 2025 MLJ 720, 2025 MLJ 720, the division bench has considered the scope of certiorari and traced the entire history from 1952 Supreme Court, and is a very detailed judgment. I only request all the listeners here to take note of this 2025 MLJ 720. By reading this, you can easily understand the scope of certiorari in one judgment itself. Earlier, there was a judgment of Supreme Court in Surya Devi Roy, 2003 6 SEC 675, 2003 6 SEC 675. The Supreme Court has analyzed the scope of Article 226 and 227 and held that it is an extraordinary original jurisdiction, and the High Court is entitled to go into the validity of any orders, including the judgment of the Civil Code under 226 and 227. This was the view taken in Surya Devi Roy. Subsequently, it was doubted by another division bench, another 2 judges bench of the Honorable Supreme Court. Therefore, the matter was referred to a 3 judges bench in 2015 5 SEC 423. 2015 5 SEC 423. Radhe Syam case, the 3 judges bench of the Supreme Court has approved the view of Surya Devi Roy. However, they took they have overruled a portion to the effect that the order passed by the Civil Court cannot be challenged under 226. The order of the Civil Court can be challenged only under 227. But rest of the orders passed by the quasi-judicial or administrative authorities can be tested under 226. This is an important decision. We have to take note of it in mind. Similarly, who should be added as a party? We have seen already the person having legal right alone can move the High Court under 227. Then against whom the writ petition can be filed? Writ petition can be filed against an authority who passed an order, and also the person having interest over the matter. So you must add the authority who actually passed the order included as a party in the writ of certiorari. But take an example. Suppose in a labor matter, an order was passed by the labor court. Management wants to file a writ petition. Then management has to file a writ petition against the presiding officer of the labor court as well as the claimant, namely petitioner in the ID. Now that issue has been settled with this Honorable Supreme Court in 2015 9 SEC page number 1. 2015 9 SEC page number 1. Only the person who is answerable to the order alone can be added as a party respondent. We need not add the labor court as a party, because the labor court is not going to contest the matter in the High Court. Labor court has passed an order at the instance of the workman. So the workman alone is enough. If you want to file a writ petition, this is a very important aspect. Normally, writ petition will lie only against the officials and state or other authorities. But the law has been settled by the Honorable Supreme Court. If the respondent who is not answerable to order impugned, then he need not be added as a party. Similarly, if you want to challenge the surcharge order passed by the district court, which is incidentally special tribunal for cooperative cases, you need not add the district court as a party. It is unnecessary. Thus, the registrar or the society alone is enough. Similarly, if you want to challenge the commission's order, Human Rights Commission's order, you can, if you want, you can add the registrar of the Human Rights Commission as a party. You will not add the commission itself, namely the chairman or members as a party, because they are not going to answer your the issue raised in the writ petition. Therefore, this is a very important aspect. In between mandamus and certiorari, there is yet another aspect, namely certiorarified mandamus, which is not a writ mentioned in Article 226 or 32. But suppose if you want to challenge an order, all right, the order has been challenged by of certiorari. That order is set aside. Merely because the order is annulled, it will not satisfy the purpose. There must be a consequential direction to protect the legal right of the person who is approaching the court. So there must be a consequential prior. If you take section 25 Court Fees Act, you can find place whenever there is a main relief is sought, you can incidentally ask for consequential relief in while filing. Whenever there is when a declaration and injunction is sought, or declaration is sought, then consequential prayer for possession or injunction can be prayed for. Similarly, wherever you want to seek annulment of or challenge the order of the authority, you have to ask for a certiorarified mandamus, that is consequential direction against the authority to pass an order in your favor or to meet your grievance. Also, there must be a consequential prayer to that effect. Therefore, merely because writ of mandamus and writ of there is a fine distinction between writ of mandamus and writ of prohibition. Writ of prohibition is concerned, you can file a writ before the order is being passed. Then writ of certiorari is concerned. Writ petition, sorry, I mentioned as mandamus. It is not mandamus, certiorari. There is a thin difference between certiorari and prohibition. Certiorari is concerned, you can challenge, you can file a writ petition only after the decision is taken. Whereas prohibition is concerned, you can file a writ even before passing the order. Suppose if you come to know that an order is going to be passed by the authority without any jurisdiction, you can file a writ petition prohibiting the authority concerned from passing the order. Take an example. Collector has taken some decision on the application made by A. Then the person who is affected, B, has again approached the collector to review the order. Then collector has passed an order reviewing his own earlier order, even without giving notice to A. Then in such a case, suppose when collector has issued a notice for reviewing the order, A can move the High Court saying that the collector has no authority because the power of review is not vested with the collector. Suppose collector has passed an order without hearing A, then in such a case, A can move the High Court to certiorari to quash the order passed by the authority, the collector, on the application made by the B. So here, mere filing of very certiorari is not enough, even assuming that he has filed. Normally, what the High Court will do in the case of this nature, that the earlier order passed by the collector was without hearing the B. The order passed in the review was passed without hearing A. So normally, both the orders will be set aside and the matter will be sent back to the collector for fresh enquiry after hearing both the parties, namely A and B. So this is the power of the High Court. High Court can do and undo anything under 226. So the power writ of prohibition is only to prevent the authority or the subordinate courts or even tribunals from traversing beyond the jurisdiction. So to prevent them from usurping the jurisdiction, which has not been conferred upon them. So this is the writ of prohibition. The fourth one is the writ of quo warranto. Writ of quo warranto. It's a very rarely used, but a very important provision in the jurisdiction is concerned. Quo warranto means nothing but show your authority. To show your authority. Suppose a public servant or even a constitution, from public servant to constitutional authority, we can file a petition. From ordinary civil servant, appointment of civil servant to even the constitutional post can be questioned by way of quo warranto on the ground that the person who has been appointed lacks qualification or is not having competent qualification to occupy that post. So it can be filed against any government servant and up to the constitutional authority. And that means anyone holding the public office as a civil servant or constitutional post can be subjected to quo warranto if their appointment is per se illegal and does not meet the requirement of the recruitment process or rules. That is the position. A leading decision on this is the judgment of the Honorable Supreme Court in the former Chief Minister's case, 2001 7 SEC 231, 2001 7 SEC 231, B.R. Kapoor, this is State of Tamil Nadu. The judgment, the case petition was filed to prevent Madam Jayalalitha from continuing as the Chief Minister of Tamil Nadu. This was the judgment, very famous case, 2001, 7 SEC 231. Another case, 2009, 7 SEC 1. 2009, 7 SEC 1. Ajay Ghosh versus Gannadasan. In this case also, an advocate has filed a writ petition challenging the very appointment of judge on various reasons. And in this case also, the Honorable Supreme Court has dwelled deep into the scope of quo warranto in 2009, 7 SEC page number 1. The very purpose of writ petition, writ of quo warranto, is to show that importance of institutional integrity is more important. Importance of institutional integrity is very paramount. And an institution is more important than an individual. If you see any judgment of the Supreme Court on quo warranto or Supreme Judgment of High Court, you can find place. The very purpose of writ of quo warranto is that an institution is more important than an individual who is occupying the post. So that is the very bedrock of the writ of quo warranto. Yet another important decision of the Supreme Court is AR 2013-78. AR 2013 Supreme Court 78. Then 2015 3 SEC 251. 2015 3 SEC 251. In fact, a writ petition was also filed for quo warranto against the Honorable Justice Dr. A.S. Anand, who retired as the judge of the Supreme Court in 2001 3 SEC 19. 2001 3 SEC 19. These are all the famous cases on writ of quo warranto. You would have seen in a number of newspapers about the quo warranto issued against the vice chancellors who were appointed without any qualifications also. So the famous decisions on the quo warranto I have given. So the law is very clear. If you want, always writ of quo warranto can be invoked to question the very appointment, because the importance of institutional integrity is paramount in any appointments. So that is the foundation of quo warranto. Then the last and final writ is habeas corpus petition. It is a very, very important provision in the Constitution itself. There are in fact, the Supreme Court in very many cases said that this is a great constitutional privilege. It's a great constitutional privilege. HEP itself is a constitutional privilege, and the first security of civil liberty. It is the first security of civil liberty, because personal liberty is a sacrosanct in every for every person. So there are two kinds of writ of habeas corpus petitions. One, statutory HEP. Another is non-statutory HEP. Statutory HEP means earlier MISA was there, then POTA, NASA, Coffee Posa, and even Act 14 of 1982. So these are all the orders passed under these enactments would be called as statutory habeas corpus petitions. Non-statutory habeas corpus petitions are if a girl was abducted and minor or major, parents or relatives used to file a writ petition to secure the missing of the person, even for some reason or other, an insane or physically challenged persons are being detained for the purpose of extracting the property, and their whereabouts can't be traced. In those cases, you can maintain the writ petition. Or even a child was taken forcibly, or child was taken forcibly to a foreign country. In those cases, you can file a writ petition to produce the body. The very basic thing of writ of habeas corpus is that to command to produce a body of a person illegally detained. To command to produce a body of a person illegally detained. You cannot file a HEP to secure a person who is in judicial remand. It is not permissible. So when detention is legal, that cannot be questioned by way of habeas corpus petition. Only when there is an illegal detention, it can be questioned. The history of HEP has been extensively dealt with by the Honorable Supreme Court, authored by Honorable Justice B.N. Bhagavati a constitutional bench. 1973 2 SCC 674. 1973 2 SCC 674. This one judgment is enough to understand the entire concept of habeas corpus petition. And in fact, while exercising the habeas corpus jurisdiction, the court is acting as a parens patriae jurisdiction. Parens patriae jurisdiction. And the welfare, the court always treat the minors or the persons who are incapable of understanding the issues, and the court is so keen to protect their interest. So the court takes the role of mother and father, namely the parents of the person concerned. That is called parens patriae jurisdiction. So in the habeas corpus matters is concerned, the Supreme Court and High Courts are exercising its parens patriae jurisdiction. This was discussed elaborately by Supreme Court in 2011, 10 SCC, 2011, 10 SCC, 781. I have said there are two kinds of habeas corpus petitions. One is statutory habeas corpus petition, another non-statutory habeas corpus petition. A very famous case of the Honorable Supreme Court is Lada Singh, 2006, 5 SCC 475. 2006, 5 SCC 475. That is, a girl and boy would have fallen in love. They would have eloped. Then parents definitely would go and chase them and file a writ, or they will try to even murder them. And many cases have happened in our country. Therefore, in order to, love is not a prohibited affair in our country, but people from two communities normally fought against each other in the event of any love affair between the boy and girl. There are number of cases these have come up for consideration, and the Supreme Court in one line said that no fetters can be placed on those who attained the age of majority. No fetters or no restrictions or no conditions can be imposed on those who attained the age of majority. The very famous and celebrated case of the Supreme Court in this is Hadia case. Hadia from Kerala. Would have seen a girl, a Hindu girl, fell in love with a Muslim boy. Then issue has been raised by all the family members, and petitions were filed. Both were major, but the judgment, the Honorable High Court has held that the girl cannot be allowed to go along with the boy, and she was around 22 years, and the division bench has observed that she has just completed, she has just reached the age of majority, so she may not be in a position to understand the worldly affairs. The Supreme Court has heavily come down and held that no, it is not our business to interfere, because the law says that once a person has completed the age of 18 years, we have to leave it to their choice. So that is why court cannot put fetters on the freedom of the people. This is a celebrated case, 2018, 16 SCC, 2018, 16 SCC 368. 2018, 16 SCC 368. Then 1976, 3 SCC 234, 3 judges bench. 1976, 3 SCC 234 is a very famous case. This has been repeatedly followed in all the subsequent judgments. Then 2009, 16 SCC, 16 SCC 360. Then 2018, 2 SCC, 2018, 2 SCC 197. These are all the leading decisions of the Honorable Supreme Court in respect of non-statutory cases. Lada Singh, I have already said. So when you can also suppose if a boy and girl approached you for their protection, you can easily approach the SP of police for seeking protection. If not granted, you can move the Honorable High Court by way of a writ petition, either for protection, mandamus to protecting their life, or even for habeas corpus petition to get the to produce the body of the girl or boy from the respondents who have illegally detained them because of the love affairs. So there are number of cases are being filed, so you can make use of these decisions. Then next comes an important aspect. Who can file a writ petition? Only the person aggrieved can file a writ petition. not a stranger to the matter can file. Even for habeas corpus petition, a stranger cannot file, but a person who is concerned with the boy, either friend or even family members, husband and wife or parents, somebody who is concerned with the detainee can file a writ petition. There is no legal bar. Similarly, for habeas corpus petition, there is no re judicata. Suppose if you have filed a habeas corpus petition challenging a particular detention order, writ petition was dismissed on some grounds. Even before the expiry of that habeas the detention period, you can move another writ petition on different grounds. So re judicata has no application at all in respect of habeas corpus petition. Similarly, the locus standi also. Locus standi means normally person aggrieved alone can move, but habeas corpus is concerned anyone having interest, whether he is having direct interest or indirect interest makes no difference. Somebody having interest over the welfare of the detainee can move the writ petition. So it is not confined only to the person aggrieved. That is the only difference. Normally, writ petition will be filed only by a person aggrieved. A person who has suffered a legal injury, a person who has suffered a legal injury can challenge the order under 226. Existence of a legal right is a condition precedent for filing a writ petition. So there must be a legal injury and existence of legal right. The person having legal right to complain of infringement of legal injury, then only he can challenge it. Suppose, take an example. An order was passed against 1A. That order he has not challenged. The order is kept alive. But some third party or stranger cannot maintain a writ petition challenging that order. It is virtually it is not maintainable. It will be dismissed, not simply dismissed, it will be dismissed with the cost. There are few decisions in which the Honorable Supreme Court has thoroughly examined the scope of locus standi. You need not go and search. I will give you the leading decisions of the Honorable Supreme Court on the question of locus standi. The first judgment, 2014 4 SCC 465. Law on the subject has been thoroughly examined. Then 2013 1 SCC 353. 2013 2 SCC 398. I will how the law has been developed. I will give you an example. All of us would aware the SP Gupta case reported in AR 1982 Supreme Court 149. AR 1982 Supreme Court 149. First, it is otherwise known as first judge's case. Namely, an advocate filed a writ petition against the transfer policy of the judges. This came up before Honorable Supreme Court. The locus standi was one of the issue which was discussed. The Supreme Court has clearly held that if not advocate, then who else will have a grievance against judges' policy transfer? And the Supreme Court has gone deep into the matter and held that advocate is part of the judicial justice delivery system. So he has say in appointment and transfer and all other incidental aspects. So this is the first judge's appointment case wherein the Supreme Court has recognized the role of advocates in the appointments and transfers. This is reported in 1981 supplementary SEC 87. 1981 supplementary SEC 81 equivalent to AR 1982 Supreme Court 149 SP Gupta case. It is a very nice judgment. We must read, because then only we can understand where we are placed in the justice delivery system. Then jurisdiction to file a writ petition. Where the writ petition can be filed. Originally, the writ petitions could be filed. Writ petition could be filed only when the High Court concerned as territorial jurisdiction over the matter. Suppose an order was passed by an authority at Delhi, you cannot move a writ petition at the Madras High Court challenging that order. And this has caused various complications. Therefore, the Constitution was amended under Article 226 subclause 2. the Constitution held that even though order has been passed by an authority which is outside the jurisdiction, if some part of the cause of action has taken place within the jurisdiction of the High Court concern, you can file a writ petition, which is analogous to section 20C of 20 subclause C of CPC. You would have seen, if some part of the cause of action or if one property is available within the jurisdiction of that particular court, you can file a suit. Similarly, this article 226 subclause 2 is almost analogous to section 20 subclause C. 226 after 226 subclause 2 after amendment says it can be filed in a place where legal injury takes place. High Court can issue a writ when the person or authority against whom the writ is issued is located outside its territorial jurisdiction if the cause of action wholly or partly arises within the jurisdiction. That is enough. And this earlier there were a number of confusions were there. Lot of constitutional judgments. AR 1953 Supreme Court 210 Constitution Bench. AR 1953 Supreme Court 210 Constitution Bench. AR 1954 Supreme Court 207 Constitution Bench. AR 1961 Supreme Court. So 61 Supreme Court 532 Constitution Bench. But now that issue has been settled by the Honorable Supreme Court in very recently 2014 9 SEC 2014 9 SEC 329. 2014 9 SEC 329. An interesting issue has come up before Honorable Supreme Court in 2011 4 SEC 300. 2011 4 SEC 300. In fact, I used the judgment in one of my case entrusted by Mr.N.Manokaran Senior Advocate for filing a HEP to secure a buy from the foreign country. This is a case where a writ petition was filed by wife of a Jawan who was confined at Pakistan. The Honorable Supreme Court said that no, we have no authority to extend our hands to pass orders to the Pakistani authorities. This was the view taken. But the Honorable Supreme Court has expressed human gesture by directing the army to ascertain and to take serious efforts through diplomatic channel to secure the Jawan who was confined illegally in the Pakistan. So this Honorable Supreme Court has held that we cannot invoke, even Supreme Court cannot invoke the Article 32 beyond the territorial jurisdiction. But however, this was an exception given. So I also used this judgment for the purpose of numbering the petition when it was entrusted by Mr. Mohan sir at the time. Then next issue is whether there is any limitation for filing writ. No. The answer is no, because there is no limitation prescribed in the Limitation Act for filing writ petition. But doesn't mean that you can file a writ petition at any point of time. It is not permissible. You must file a writ petition within a reasonable period of time. In fact, courts have held that writ petition filed after 1 year or 2 years are dismissed on the ground of laches and delay. This was discussed by the Honorable Supreme Court in 2019 15 SEC, 2019 15 SEC 35, 2019 15 SEC 35, 2019 4 SEC, 2019 4 SEC 500, 2013 6 SEC 515. So there is no limitation. You can file a writ petition, but it must be filed within a period of some time. Take an example. If some seniority is an issue, seniority in service is an issue, you must challenge it within a period of 6 months or 1 year. Suppose if you have filed a writ petition after 3 years or 4 years, in the meantime, several persons in the list would have been considered for promotion and they would have been settled in various higher posts. So if the seniority is disturbed after 4 years and 5 years, what will happen? There will be a problem or anomaly created in the administration. Therefore, normally, if writ petition is filed blatantly and filed without any explanation or any reason for delay, then it will be dismissed only on the ground of delay and laches. There are cases in which even the orders are being communicated after 1 year. If you see, sometimes I have seen order has been signed one particular day, but it has been communicated after 8 months or 1 year. It so happened in so many cases. Or in some cases, you even may not know the order passed, because the order would have been passed behind your back. So you may not even aware of the order. Then you must say in one paragraph that this order was kept in abeyance and I was not even aware of it. There are judgment of Supreme Court which says that if an order passed without hearing the person affected is a nullity in the eye of law. And there are cases. So some orders would have been passed behind your back at the instance of opposite party. It would have been kept quiet. It so happens in many cases under 47A of the Stamp Act. If you see 47A, the authorities will issue Form 1 and Form 2 before ascertaining the deficit stamp duty. But when final order is passed, they never used to send it through RPID. They will simply send it through ordinary post or even or some other means, but it will not be communicated to you. So in such a case, you can say that the order has not been communicated. It was communicated only at a later point of time, and you can explain those causes in your affidavit for the purpose of maintaining the writ petition. I have already given a fine distinction between Article 32 and Article 226. We have seen 32 could be invoked only for violation of fundamental rights. 226 is not only for violation of fundamental rights and also for any other cause. There are a number of cases. I will give you the list of cases in which the Supreme High Courts have entertained for other causes also. In fact, as Mr. B. Mohan sir said, the founding fathers of Constitution placed no limitations. Founding fathers of the Constitution have imposed no limitations under Article 226, except imposing some self-imposed limitations. It is for the court to choose its own limitation. There is no limitation for the power of the Honorable High Court under 226. If you read provision, it says that for any other purpose. If you are any order passed adversely against you, you can file a writ. Or any authority usurped the jurisdiction without authority, you can file a writ petition. Or if no action has been taken on your representation, you can file a writ. There are a number of cases I can cite, and even we can file a writ petition for Jallikattu, or even for cockfight, or even to lay a road. Even now under during COVID, under disasters management, writ petitions are being filed to direct the government to pay money to the aggrieved persons. So the High Court has unfettered power under Article 226 to render justice. It is not only confined to the fundamental right. And this position of law has been well settled by the Honorable Supreme Court in first AR 1953 Supreme Court 210. AR 1953 Supreme Court 210, 1954 Supreme Court 440, 1954 Supreme Court 440, AR 1955 Supreme Court 332, 55 Supreme Court 332, 7 judges, constitutional bench, 7 judges. AR 1964 Supreme Court 477, AR 1964 Supreme Court 477. Then 1997 9 SEC, 1997 9 SEC 377. So another celebrated decision by the Honorable Justice Krishnaiyer. 1976 2 SEC 82. 1976 2 SEC 82. There are a number of other decisions, but I have confined only to the very leading decisions on this aspect. So the power of High Court, you cannot confine the power of High Court to a particular aspect. It can be filed. And even High Court has its own self-imposed restriction that we are not saying anything. But you can invoke High Court for the purpose of ventilating the grievance of the party. Then, against whom the writ petition can be filed? Writ petition can be filed only against a state, or other local or other authorities. Writ petition can be filed against a state, local or other authorities, as defined under Article 12 of the Constitution. You cannot file a writ petition against an individual. It is not maintainable. You cannot file a writ petition against an individual. Writ petition will lie only against an authority of the government. You cannot maintain against a writ petition against a private individual. It is not permissible in law. This issue has come up. Number of judgments it has come. It has been finally discussed by the Honorable Supreme Court in Ramana Dayaram Sethi case that is reported in 1979 3 SCC 489. 1979 3 SCC 489. Ramana Dayaram Sethi case. Then 1975 1 SCC 421. 1975 1 SCC 421. You may wonder as to why I am citing the old decision. These judgments are repeatedly being followed in all the subsequent decisions. So these decisions are authority on this subject. Then famous GTV case 2005 4 SCC 649. 2005 4 SCC 649. Then another important case 2005 5 SCC 741. 2005 5 SCC 741 BCCI case. In fact, the Honorable Supreme Court has held that Board of Cricket Council of India is not an authority under Article 12. It is not an authority under Article 12. But writ against the BCCI will lie because now sports is an important event in India. Sports is an important event in India. And even though BCCI is not controlled by any of the limbs of the government, still it has a public duty, and the sports not only in India and all over the world plays an important role in our day-to-day life. It has some public function. Therefore, it has a public function. Therefore, the Supreme Court has held that BCCI is amenable to writ jurisdiction under Article 12. Under Article 226 of the Constitution of India. This was rendered by 5 judges bench of the Honorable Supreme Court. BCCI case rendered by 5 judges bench. Then, if you take Article 12, it says that state means including other local, including the local and other authorities. What is local and other authorities? Local means against panchayat, in ground level panchayat, then village panchayat, town panchayat, municipalities and corporations. All will come within the purview of the word local authority under Article 12. So you can file a writ petition against the village panchayat, town panchayat, or municipalities and corporations. Similarly, other authorities. What is other authorities? The other authorities is not coming within the purview of state, but they are being controlled directly or indirectly, either by administrative control or by financial aid. Those authorities also will come within the purview of Article 226. Namely, you can take this electricity board, then Stock Exchange of India. So similarly, there are a number of authorities. There are independent. They are created by an independent enactment, but still they are coming under the State Finance Corporation. So they are independent authority functioning under independent act, but still they are amenable to the jurisdiction because the government is having either administrative or financial control over the those authorities. What is that definition? That is the Supreme Court in 2015 4 SCC 670 2015 4 SCC 670 has clearly defined the meaning of local or other authority. Local or other authority. Yet another case, you have seen there are public trust are running into educational institution in all over the state. This is the state of affairs. If you take any institution is being run by, any educational institutions are being run by a public trust. So if a public trust is running an institution and carrying on public function, which comes within the jurisdiction of Article 12, that is reported in 1989 2 SCC 691. 1989 2 SCC 691. In yet another case, 1997, 3 SEC, 5 neighbor has opposed for granting electric service connection. Normally, the electricity board will direct us to go and convince the other side for drawing the line. It is not so. The purpose of getting way leave is the duty of the board. There are a number of litigations have come on this aspect. 2013, 6 CTC 849. 2013, 6 CTC 849. 2014, 1 Law Weekly 865. 2014, 1 Law Weekly 865. So, way leave is concerned, it is a duty of the authorities concerned. It is not our botheration. Then, repeated filing of writ petition. We have seen some persons, some unscrupulous people used to file writ petitions to wreak vengeance. This kind of filing repeated writ petition for the same cause would amount to contempt is the view taken by Supreme Court in 2008, 1 SEC 560. 2008, 1 SEC 560. And we have already discussed that the Supreme Court, the writ jurisdiction cannot be invoked for the purpose of deciding complicated facts. And there are one exception in which the Supreme Court in 2004, 3 SEC 553, 2004, 3 SEC 553, ABL International Limited, ABL International Limited. You please take note of this judgment, which may be helpful in our day-to-day practice. This is the only case in which Supreme Court has held that if the facts are not complicated, even a money recovery is permissible under the writ petition. Even a money recovery is permissible under writ petition. This I have used it. A public limited company entered into a contract and later failed to pay that contract was not worked out. Then when my client approached them to get back the amount, they said we will not refund by invoking forfeiture clause. I have filed a petition by citing this judgment and I won the case. So this is the only case in which Supreme Court entered by Honorable Justice Rumapal. This has been repeatedly followed number of cases. Supreme Court has held even evidence can be taken. In this case, Supreme Court has held even evidence can be taken. So we cannot undermine the power of the High Court under 226 is the view taken by the Honorable Supreme Court. Reported in 2004, 3 SEC 553. We must read for our practice. Then no writ in Sarfazi matters. Sarfazi case, a number of parties used to approach the High Court, but all the writ petitions will be dismissed by citing the judgment 2018, 3 SEC 626. 2018, 3 SEC 626. So the remedy in Sarfazi is only before the DRT, not High Court. 226 can't be invoked. Then for public meetings, we have seen there are whenever permission is sought, the authorities for various reasons and also for political reasons, they used to refuse permission to conduct public meetings. There are celebrated decisions of the Honorable Supreme Court. 2020, 10 SAC, 2020, 10 SAC 439. 2021, 1 SEC page 1, 2021, 1 SEC page 1, 2013, 16 SEC 430, 2013, 16 SEC 430, 2019, 2 CTC 135, 2019, 2 CTC 135, 2019, 2 CTC 149, 2019, 2 CTC 149. There are a number of judgments from 1960s, but I am giving only the latest decision. You can refer those decisions, old decisions also in the present citations. And whenever your right to property is infringed, immediately there was a view. It was originally right to property was a fundamental right, but the fundamental that concept was taken away by amending the constitution by 17th amendment. That was taken away. So right to property is no longer a fundamental right, but it is a constitutional right. It is a statutory right. You please refer Article 300 capital A of the Constitution. 300 capital A of the Constitution says that no one can be deprived of his right to property except in the manner prescribed by law. So right to property, no doubt, is not a fundamental right, but it is a constitutional right. It is a statutory right. It is a human right. You please refer 2020 9 SEC 356, 2020 9 SEC 356, 2020 2 SEC 569, 2020 2 SEC 569. we have seen in our day-to-day life, there are loudspeakers everywhere during election campaign, or even during temple festivals, or even other religious celebrations. Loudspeakers are causing a nuisance, and every affected person is having right to approach the High Court, complaining action for his comfortable living. This was discussed by the Honorable Supreme Court in AR 2005 Supreme Court 3136. AR 2005 Supreme Court 3136. 2018 2 CTC 508. 2018 2 CTC 508. AR 2016 Supreme Court. AR 2016 Supreme Court 3805. 3805. 2018 3 Law Weekly 400. 2018 3 Law Weekly 400. AR 2017 Sikkim 22. AR 2017 Sikkim 22. Another important aspect is concerned, whenever a particular order is challenged before High Court in 226, the other side will meet your points raised in the writ petition by adding something in the counter. That view is impermissible in law. Every order challenged in the writ petition has to be tested only on the basis of the reasons so stated in the order. So whether order is correct or not could be tested only on the basis of the order passed. They cannot add something in the counter affidavit. They cannot supplement something in the counter affidavit. This is not permissible in law. This position of law settled by the Honorable Constitution Bench in 1978 1 SCC 405. 1978 1 SCC 405 Constitution Bench. Followed in 2019 11 SCC 361. 2019 11 SCC 361. Then, very recently, the Madras High Court Division Bench has taken the view that in every writ petition, you can ask only one prayer. More than multiple prayers are impermissible. If you want to ask one prayer, then constitutional relief you can ask. Suppose the order is sought to be quashed, it can be certiorari. Then constitutional direction mandamus, certiorari by mandamus. You cannot add multiple prayers, yes, like in the civil suit. You know well that in civil suit, you can ask any number of reliefs, provided you should pay individual court fee under section 6 of the Court Fees Act. That is not permissible in the writ petition view taken by the Division Bench 2020 5 MLJ 766. 2020 5 MLJ 766. Division Bench on reference. So multiple prayers cannot be claimed in the writ petition. Then lastly, CPC, application of CPC is completely excluded in the writ petition. For writ petition, please refer explanation to section 141. Explanation to section 141 CPC. 141 CPC. Finally, like order 39 subclass rule 3 or 3A is there, that it should be disposed of within time frame. Many of even the lawyers who are practicing the High Court are not using this provision. Article 226 subclass 3, if you read it, whenever an interim ex parte order is granted by the High Court, the other side, soon after entering appearance, once he files a counter affidavit with the vacature petition, that should be disposed of within a period of 2 weeks. If not, stay automatically stands vacated. I am only placing it to kindle the mind of the listeners here, to point out this provision, to pass an order to vacate. Because wherever interim order is passed without hearing the person affected, then that person is respondent, is entitled to approach the High Court along with vacate stay. That should be disposed of within a period of two weeks. If not, automatically stands vacated is the constitutional provision under 226 subclass 3. With this, I conclude my discussion.